Welcome to the deep dive. Today we're really peeling back the layers on something complex, a specific draft law in Ukraine, but it touches on huge issues, individual rights, technology, state power.
Absolutely. We're looking at draft law number 1405 and specifically diving into an analysis by Dr. Viacheslav Morgun. His title kind of says it all. State in a smartphone without a state under law. Dictatorship of Algorithms.
A dictatorship of algorithms. That's quite a hook. So our mission today is to unpack why a law that's being sold as, well, necessary digitalization for things like debt collection is getting diagnosed as something much more sinister and unprecedented digital apparatus of coercion.
Right, and to even begin understanding that coercion angle,
Mm-hmm.
you really have to grasp the sheer scale of the problem this law is supposedly trying to fix.
You mean the debt?
Exactly, the accumulated utility debt. We're talking unpaid bills for heating, water, electricity, the basics. Dr. Morgan kicks off with the figure. It's currently over 106.6 billion UAH.
Wow. Okay, 106.6 billion Ukrainian hryvnia. Just for context, how big is that really?
Yeah, it's staggering. It actually exceeds the country's total annual budgets for things like education or healthcare. It's a systemic figure.
So it's way beyond just, a few people falling behind on bills. The source argues this number points to a complete breakdown, right? Like a collapse in the whole relationship around utilities.
That's the core argument. It suggests the billing itself, what companies are charging, has become totally disconnected from whether people actually got the service or if the quality was even acceptable. When you have debt that massive, it signals a fundamental lack of trust in the system itself.
And this huge debt, this 106 billion UAH figure, that's the pressure cooker that led to this draft law 14,005. This is the Trojan horse idea you mentioned.
Precisely. The law is marketed, publicly promoted, using very sympathetic goals, like making it easier to collect alimony for kids, which everyone agrees is important.
Okay, sounds reasonable so far.
But the author argues the real unstated goal is to build this automated machine, what he calls a digital guillotine, specifically to collect this massive and frankly questionable utility debt that's been generated by monopolies, often state-backed ones.
Right. So we're looking at a law where the hidden agenda, according to this analysis, is basically to rubber stamp and automate collecting any amount of monopoly bills you for. It just bypasses the whole question of, did you actually get what you paid for?
Exactly. It kind of shifts the state's role from, well, ensuring justice or mediating contracts into just being a highly efficient collection agency for these big players. The focus isn't fairness, it's speed and total collection.
Okay, but we need to be fair here. Even Dr. Morgan, the critic, points out there is one genuinely positive thing in this bill, Article 39-1, right? He calls it the cynical bait.
Yes, and it is a real improvement. It addresses a major frustration. Right now, if your bank account gets frozen because of a debt, even after you pay it off, getting that freeze lifted is a nightmare.
Yeah, I can imagine. Weeks of paperwork, calling people.
Weeks, sometimes months. It's pure bureaucratic hell. Think about a small business owner whose account is locked. Or maybe a soldier at the front whose salary suddenly gets frozen over some old, maybe small utility bill they've already paid. It's paralyzing.
So what does Article 39-1 do?
It fixes that specific problem. It mandates that once the debt is confirmed as paid, the automated enforcement system, the ALAs, has to automatically tell all the banks to lift the freeze on your accounts, like the very same day.
Okay, that sounds genuinely helpful. Immediate relief for people caught in that bureaucratic loop. So why call it cynical bait? That seems harsh if it's a real fix.
Well, the argument is that it's a relatively minor procedural fix, a sweetener used to make the whole package seem reasonable and efficient. It distracts from the much bigger, more fundamental changes happening underneath, the ones that shift power massively towards the monopolies and potentially undermine constitutional rights. It's like fixing a leaky faucet while the foundations are crumbling.
Okay, let's dig into those foundations then. The source makes a pretty bold claim that this whole debt crisis, the 106 billion, wasn't an accident. It was the result of deliberate policy over decades.
Correct. And the argument goes right back to the Ukrainian constitution. Dr. Morgan argues that the way essential life support systems, water, heat, energy were privatized actually violates some core constitutional principles.
Which principles are we talking about?
Primarily Article 13, which states that natural resources, think water, gas, the land itself, belong to the Ukrainian people. And also Articles 140 to 143, which give local communities, the territorial communities, the right to manage their own communal property.
So the argument is, giving control of these essential, naturally monopolistic resources to private companies wasn't just a policy choice, it was actually unconstitutional. It took away the people's ownership and weakened local government.
That's the thesis. that it wasn't really economic reform in the public interest, but a way to strip assets and power from the people and their local representatives, essentially making local councils administrators for private interests rather than governing bodies.
Now, the source uses some really strong language here, calling this privatization a criminal special operation.
Hmm.
That sounds extreme. Isn't the standard argument that privatization brings efficiency, investment, better services eventually?
That's the standard line.
Yes.
But the author counters this using classic economics specifically. Adam Smith's water and diamond paradox. Remember that one? Water is essential for life, but often cheap, while diamonds are useless but expensive.
Because value isn't the same as utility, right? Depends on scarcity.
Exactly. But what happens if you create an artificial desert? Suddenly, that essential thing, water, becomes incredibly valuable, priceless even. The point is, demand for truly essential things, heat in winter, drinkable water, basic energy, is inelastic. You can't just choose not to buy it. You need it to survive.
So normal market rules like competition driving down prices, they just don't apply to these kinds of essential services.
Right. They fall under what economists call public economics. The goal shouldn't be maximizing profit. It should be guaranteeing access to life essentials for everyone, reliably and affordably.
Okay, so connecting that back, the argument is that privatizing these utilities was like deliberately creating that artificial desert, seizing control of this sip of water, and then forcing citizens to buy back what was once theirs, but at inflated prices.
That's the framing. And the evidence presented for this comes from official sources, like reports from temporary special commissions, TSK, of the Ukrainian parliament, the Verkhovna Rada. They documented massive financial extraction, especially within monopolies like Naftogaz.
Naftogaz, the state gas company, what did the reports find?
They found it was basically transformed from a state entity into something acting like a private, profit-hungry corporation, despite holding a monopoly. The gap between the actual cost of extracting Ukrainian gas and the price charged to the public was enormous.
How big a gap are we talking?
Well, the report cited the self-cost of domestic gas at around 810 to 223 UAH per 1,000 cubic meters. But the price set for ordinary people was nearly 8,000 UAH 7960, to be exact.
Whoa, that's like 7 or 8 times the cost. Where did all that extra money go, according to the source?
The analysis attributes it to a combination of things. Huge super profits for the monopoly, systemic waste and inefficiency, and frankly, corruption built into the distribution and pricing.
And it wasn't just high prices. There was another angle, too. Something about debts and management pay.
Yes, a sort of dual extraction. First, you had astronomical salaries and bonuses for top management. The source points to the infamous case of the former Naftogaz head, Koboyev, and a premium worth 229 million UAH, millions flowing to individuals.
229 million UAH derived from the price of essential gas.
Derived from that massive markup. And second, the structure seemingly drove the municipal heating companies, the TKEs, deep into debt, something like 95 to 124 billion UAH. The analysis suggests this was deliberate to make them financially unviable and ripe for takeover by the larger monopolies later.
Okay, let's tie this all together. If we accept this analysis, the 106.6 billion UAH utility debt isn't just unpaid bills. It's largely made up of inflated prices, inefficiency, corruption, these massive bonuses. Essentially, the financial fallout from what the source calls documented economic crimes.
That's the conclusion. And therefore, Draft Law 14,005 isn't just about modernizing debt collection. It's seen as a deliberate legal tool designed to forcibly collect the profits of this alleged systemic corruption directly from the population. It's about making the public pay for the extraction.
Wow. Okay, so that sets the stage. Now, let's get into the mechanics of the law itself. This is where the dictatorship of algorithms idea really comes into play, right? How does this law actually change the legal relationship?
Fundamentally, it basically flips the script on who has to prove what. It legally cements a presumption of guilt for the consumer.
What does that mean in practice?
Well, normally, in a contract, if someone wants payment, they have to show they delivered the goods or service. Under this new system, the utility company just issues a bill. That bill, generated by their system, is almost automatically treated as legally valid debt. The burden then shifts entirely onto you, the citizen, to somehow prove you didn't receive the service or that it was inadequate. The bill itself becomes like a mandatory tax, not a payment for a service rendered.
And this ties into how courts handle these cases. The simplified judicial order process, that sounds like a key part of the mechanism.
It's absolutely central. This process lets the monopoly company basically bypass a full court hearing. They don't need to submit detailed proof they provided the service, they just submit their billing records. A judge can then issue a judicial order demanding payment, often without ever calling the consumer in or hearing their side of the story.
So it's one-sided, and there's a time limit involved.
Yes, and this is the trap. You typically have only 15 days after being notified if you are properly notified to contest this order.
Only 15 days.
Think about who might miss that window. An internally displaced person, an IDP, who's fled their home and isn't getting mail at their old address. Or a soldier deployed in a conflict zone, not exactly checking their postbox regularly. If you miss that 15-day deadline, the order becomes legally enforceable automatically. You're judged liable without ever setting foot in court.
And once that happens, once that order is locked in, it triggers this social shutdown you mentioned through the Unified Register of Debtors.
Exactly. This isn't just about freezing a bank account anymore. Getting listed in this central debtor registry has immediate, automated consequences across different government systems.
Like what? What actually happens?
The moment your name hits that list, automatic block from the Ministry of Internal Affairs if you try to re-register a car. Automatic refusal from any notary to certify any kind of real estate deal, selling, gifting, mortgaging your property. Forget it. Plus, banks are mandated to immediately report any new account you open so it can be instantly frozen too.
So it's not just financial difficulty, it's like being digitally excluded from basic economic and social functions. An algorithm, based on an unchallenged bill, can effectively paralyze your life.
That's precisely the dictatorship of algorithms concept. It's a system of total control and automatic punishment. The author argues it replaces fundamental human rights and due process with an algorithm that can, with a click, cut someone off from participating in society, even if the debt itself is completely bogus.
Let's talk about who benefits and how this kind of power might already be playing out even before the specific law is passed. You mentioned the alimony ruse earlier.
Right. Collecting alimony is obviously crucial, a socially necessary goal. But the source argues it's being used here as the feel-good justification, the public face, to sell this powerful enforcement mechanism. The real prize for the architects of this system, though, isn't alimony. It's the vastly larger pot of gold in those disputed utility debts.
And the law also empowers private enforcement agents, right? How does that fit in?
It creates a whole industry. These private executors are paid a percentage of whatever they collect. So, they have a direct financial incentive to go after debts aggressively. They effectively become a private army for the monopolies, motivated by profit, not necessarily by justice or fairness. And guess which debts are easiest to collect with automated systems? Those utility billings.
Are there examples of how these systems, even now, can generate questionable debts?
Oh, absolutely. The source provides a pretty stark example involving Kyivtoplenergo, the Kyiv heating company. They allegedly billed one resident 50,000 UAH, a huge sum for hot water service, in a building where the hot water pipes hadn't even been functional for over 20 years.
So the billing system just invented a debt, generated profit from nothing.
Essentially, yes. It highlights how automated systems, detached from reality, can just churn out claims based on flawed data or algorithms, creating debt out of thin air.
Okay, that's bad enough. But the second case study you mentioned involving DTEK YASNO suggests something even more disturbing: active collusion with authorities.
This one is critical because it points towards a potential systemic issue, not just errors. The allegation is that employees from DTEK, a major energy company, entered someone's private property without a court order to disconnect their electricity.
Which is illegal, presumably.
Absolutely. It's potentially a violation of Article 162 of the Criminal Code, illegal entry, violating the sanctity of the home, a serious offense. But it didn't stop there. After this alleged trespass, the victim's personal data was then apparently passed illegally to a debt collection agency, Delta M Ukraine, who then allegedly began a campaign of psychological pressure and extortion.
Okay, so illegal entry, illegal data transfer, harassment. What makes this point towards systemic collusion is how the police handled it, right?
Exactly. This is the crucial part, what the author calls the smoking gun. The victim filed a formal criminal complaint with the local police, the Golosiev District Police in Kyiv. But according to the source, the police systematically refused to even register the crime in the official Unified Register of Pretrial Investigations, the NABU.
They have to do that, don't they? Isn't there a time limit?
They are legally required to register it within 24 hours under Article 214 of the Criminal Procedure Code. But here, they allegedly just refused. They reportedly ignored multiple court orders compelling them to register the case and investigate. And eventually, they just closed the case entirely without even providing the required documents to the victim.
So, the system designed to protect citizens seemingly protected the corporation instead. The complete failure to even start an investigation suggests, well, it suggests the system itself might be compromised.
That's the alarming implication drawn in the analysis. It points towards a potential coordinated effort, a systemic breakdown, where law enforcement might be acting or failing to act in a way that shields the monopolies from accountability.
This paints a pretty bleak picture. If the system is potentially this skewed, is there any alternative path proposed? A way forward that actually centers the citizen, not the monopoly?
The analysis argues that yes, there is, but it requires a fundamental shift in thinking. Moving away from seeing the citizen primarily as a source of revenue, a wallet, and back towards the constitutional principle, Article 3, that the human being is the state's highest social value.
So, starting with a different philosophy, like a presumption of consumer innocence instead of guilt.
Exactly. Assume the citizen is acting in good faith unless proven otherwise. From that starting point, Dr. Morgan outlines three concrete, quite radical steps.
Okay, what are they?
First, confiscation in return. Basically reverse the allegedly illegal privatization. Restore essential infrastructure, water, energy, heating systems back to public ownership, either state or, crucially, communal ownership managed by local territorial communities, in line with those constitutional articles we discussed earlier, 13 and 140, 143.
So, taking back control of the assets, what's the second step?
Second, a public monopolist model. Instead of private companies seeking profit, each local community would have a single public legal entity responsible for providing these essential services. Its goal wouldn't be profit, but sustainable operation at economically justified self-cost. Service delivery, not financial extraction.
Okay, public ownership, service focus.
Yeah.
What's the third piece? How do citizens get a say?
This is really interesting. Third, empowering citizen control through OSN. These are neighborhood self-organization bodies. The proposal is to give these local bodies real legal power, specifically the power to issue collective claim acts if a service isn't delivered or is substandard.
A collective complaint, what power would that have?
Crucially, this claim act wouldn't just be a complaint letter. It would have the legal status of a primary accounting document, the effect. It would immediately suspend the billing for that service to the affected residents until the problem is investigated and actually resolved.
Wow, that flips the dynamic completely. No more pay first, then maybe we'll fix it. It puts the power back in the hands of the community to demand quality service before payment is due.
Precisely. It breaks the current model where you're forced to pay questionable bills and then fight for refunds or fixes.
So, looking at the whole picture presented in this analysis, the final diagnosis is pretty damning, isn't it?
It really is. The author concludes that what has been built and what laws like 14005 aim to solidify is a complete five-stage system of controlled resource extraction. It essentially describes the state apparatus acting like an organized criminal group that has captured key functions of power, legislative, executive, judicial, to ensure the continuous extraction of wealth from the population, all while using corrupted legal structures to guarantee impunity for the extractors.
And the danger isn't just the current exploitation, but the long-term consequences.
Yes, the current model, as described, is all about taking money out. There's little incentive for reinvestment in the actual infrastructure, the pipes, the power lines. So while profits are maximized now, the system itself decays. The author warns this path, accelerated by digital enforcement tools, leads towards systemic collapse and ruin once the capital has been fully extracted. The root problem isn't just corrupt individuals, it's the laws and regulations themselves that enable private interests to control and exploit public necessities.
It suggests the country is at a real crossroads. Either reclaim public ownership and power, as the Constitution outlines, focusing on public good, or allow this digital apparatus to accelerate what the source calls the systematic destruction of the future. A really provocative thought to end on for you, the listener. If this analysis holds weight, what systemic changes would you see as most critical to break this cycle of extraction?
Something to really think about.
Thank you for joining us for this very deep dive today.